Thank you very much, also from my side, to the European Internet Forum for hosting this indeed very timely debate on the Digital Markets Act, for which we tabled our proposal on the 15th of December. So we are at a very early stage of co-decision procedure, and I'm very happy to be here with you today to try to explain some key elements of the Commission proposal. Thank you also to Mr. Saliba for setting the scene so well today. But not just today, also already in the European Parliament report, indeed, to which you referred and in which you called for an internal market instrument imposing ex ante regulatory remedies on large operators with significant market power. And that is exactly what the Digital Market Act aims at. The objective of the Digital Markets Act is, in fact, two ways to ensure that markets remain open and contestable despite the presence of gatekeepers in core platform services, so that businesses in the EU, large and small, can compete fairly online as they do offline. The second objective is to avoid unfair conduct by such gatekeepers towards either their business users or final consumers. And the instrument that we have chosen for this objective is one of ex ante regulation, an instrument in which do's and don'ts, obligations and prohibitions, are set out in the legislative act itself. And those obligations and prohibitions will apply automatically to designated gatekeepers. So contrary to what exists in the UK, for example, or it's now foreseen in the German Competition Act, we have not chosen for a case-by-case assessment where remedies are tailored to each individual companies, but we have deliberately made a choice in favor of speed and legal certainty, which we believe is created by specifying in the Digital Market Act itself the obligations and prohibitions that will apply. The designation as gatekeeper does require a Commission decision, and the designation mechanism is one based on a combination of quantitative and qualitative criteria. The key principle is that you can be designated as a gatekeeper if you, as an undertaking, have significant impact on the internal market, if you operate a core platform service which serves as an important gateway for business users to reach end users, and if you enjoy an entrenched and durable position for that core platform service. If you meet the quantitative thresholds which are stipulated in the Digital Markets Act, they relate to turnover, to market value, to numbers of business users and end users, and to whether those figures are met for the last 3 financial years. If you meet those quantitative thresholds, then you are presumed to be a gatekeeper and you can be designated fast. If you do not meet the quantitative thresholds, you can still be designated, but then on the basis of a more detailed, full-fledged market investigation to verify whether, as an undertaking, indeed you meet the substantive criteria which are set out in the Act. But once designated as a gatekeeper, as I indicated before, this is a core feature of the DMA that a series of obligations and prohibitions foreseen in Articles 5 and 6 will apply to you automatically. There is some room for a dialogue on the implementation modalities for the provisions stipulated in Article 6. And there is limited room for a temporary switch off of some obligations and prohibitions in case of overriding public interest. But as such, the idea is that the obligations and prohibitions kick in automatically once you are designated as a gatekeeper. You'll find in the Digital Market Act proposal a system of enforcement where the Commission indeed acts as regulator at the European level. I think that's quite a novel feature of the DMA. And the Commission having investigative powers to implement that task, investigative powers quite similar to those present in competition law. You'll also find due process rights, which are stipulated. Of course, decisions taken under the Digital Markets Act have far-reaching consequences for operators, so it's only normal that the due process rights are also preserved. That's an important point for us as Commission as well. As Mrs. Saliba indicated, the sanctions foreseen in the Digital Markets Act for violating the prohibitions and obligations contained therein can go up to 10% of turnover. And in case of systematic non-compliance, which we hope, of course, will not occur, because the idea is that the Digital Markets Act will have a preventive effect on the market, but should nevertheless systematic non-compliances occur, there is the possibility, on the basis again of a market investigation, also to adopt behavioral or even, in case that's necessary, structural remedies. So that in a nutshell, in terms of some core building blocks and some key features of how the proposal as we have foreseen it is conceived. Now, where are we in the process? As I said, we're starting. And no doubt, as Mr. Saliba also said, there is a margin to improve the text. We as Commission look very much forward to engage with both Council and Parliament. The discussions on the text have started already in the Council Working Party, where the file has been attributed to the Competition Working Party. In the Parliament, the file has been attributed provisionally to IMCO, but I understand that other committees are also taking a keen interest. But once their decisions on attribution are taken and the rapporteurs are appointed, we look forward to really engage with the Parliament as well. We have already been presenting the initiative also in the IMCO, taking active part in events such as this one to make sure that we can present the proposal as we have foreseen it. And as I said, we very much look forward to engage with the co-legislators and to facilitate what hopefully will become a fairly rapid legislative process. Thank you very much.